of this summit. And it gives me great pleasure to introduce Director of Jury Research Services with the National Legal Research Group, Dr. Jeffrey Frederick. Welcome. It's over to you.
Thank you very much, Charlie. As Charlie said, my name is Dr. Jeff Frederick, Director of Jury Research at the National Legal Research Group in Charlottesville, Virginia. And I'll be the moderator today, and I'll be sharing a little bit about what we learned in both the online courtroom project's virtual jury trial in terms of jury selection, and also the Arizona jury simulation project conducted for the Maricopa County Civil Innovations Task Force under the direction of Judge Pamela Gates, and also co-expert with my good friend and colleague, Karen Lisko from Perkins Coie. Now, what I'd like to do is to thank Richard Gabriel for all his work on this, the online courtroom project, and for Nita for putting together a great two-day jury summit. Now, we have a great panel for you today. We have the Honorable Matthew Williams, who is a judge in King County Superior Court, and they've been on the forefront of conducting jury trials both in person and virtually, and so we're really pleased to have him here today. Also, we have Jennifer Smitrovich from Favros Law. She just completed a 3-week medical negligence jury trial. It was in person, but the jury selection was on Zoom. And then we have Austin Yancey, who's an associate at Reed Smith, who just completed the 55-day Zoom asbestos jury trial from start to finish on Zoom. And so I'm sure we'll hear some great thoughts about all these things. I'll remind you at the bottom of your screen, there should be a Q&A tab that you can enter your questions. We're going to save a lot of time near the end of our program so that you have an opportunity to submit those questions and that we can answer as many of them as we can. Now, we're going to be covering a variety of topics. We're going to be covering online juror questionnaires. We're going to be covering online questioning in general. And then we'll be covering juror questioning in particular, managing communications between the judge and the attorney, and also within the team itself, and also exercising challenges. And what I'd like you to do is keep in mind in the beginning, as you listen to our observations, is that jurisdictions differ, judges differ in what they allow, and what we wanted you to do is take what we can offer and then adapt it to your circumstances and to give you the best chance of having the most positive experience with a virtual jury trial. Now, at the end of our slide deck, and I encourage you to download the slide deck. At the end of the slide deck, we have a number of best practices for each of the topics that we're going to be considering. And we're not going to be able to talk about all of them, but I want you to go ahead and download those so you can have them in your arsenal. Now, we're going to start off by having Judge Williams kind of set the stage, if you will, and talk about how they conduct jury selection in King County. But first, I want to go ahead and remind you, I'm sure that you've seen this slide before, basically to be able to maximize the slide. It's a complex slide, but this way you can maximize the visual field on that. So with that said, I'd like to go ahead and turn it over to Judge Williams and kind of set the stage for us, if you please.
Thanks, Jeff. Dr. Frederick. In King County, what we've gone to complete, both in criminal and civil, our jury selection is primarily done exclusively online using a Zoom platform. We've made it inclusive, and you have here the slide that is our basic roadmap. You'll notice it's very busy. I also want to note that especially after the lessons learned in Ms. Mitrovich's trial, we've actually both simplified and we've evolved this process. We have not eliminated the option for jurors to come into the courthouse in person. We've simply expanded it, and we've allowed our jurors to be able to have the option, and most of them do pick the option, have the option to be able to participate remotely. And the effect of that has been essentially that we've flipped a lot of the processes that were, when you think of jury administration, that we used to do. So jurors no longer come down, sit in a big room with a whole bunch of other people to watch videos and get oriented. Our orientation is done asynchronously. It's done online. And to the extent that we have jurors that are unable to participate that way, we make other arrangements. And then, as you can see from the diagram, usually the Friday before, the lawyers and the judge have finalized a detailed case-specific questionnaire. And that questionnaire gets a lot of the information that you would acquire at the beginning of your voir dire, those general questions. So coming into the voir dire, the lawyers have a very clear understanding as to basically where each jury is coming from in their life experiences. On the first day, instead of immediately starting with jury selection or opening statements, what we have is what we call the hardship hearing, and that's done exclusively on the questionnaire. The lawyers and the judge sit down and they go through line by line. Usually there's about 90 jurors that have completed the questionnaire, 90 to 120. And we go through line by line, and we identify those individuals that really we need to excuse because of a hardship, especially in these times. Interestingly enough, a lot of the times that's because people have kids at home. So those individuals are essentially excused right in front. They've never come down to the courthouse. Then the juror sends out, at this point we now have an idea of who the panels are. And you'll notice on day 4 where it says the panels, those now actually occur usually on Tuesday rather than on Thursday. So we're moving along, and we'll usually have 2 panels in the morning, 2 panels in the afternoon. It's an evolution from what we learned from Ms. Mitrovich's trial. And our last panel is frequently an in-person panel, although it frequently doesn't have very many people in it, because we want to make sure we maintain the randomized order of the jurors. Then we'll proceed, usually on Wednesday or Thursday, we'll proceed with opening statements because we've selected the jury, but you'll notice there's something that occurs before trial starts. On the record, but outside the presence of the jury, we have what we call the peremptory or GR37. In Washington State, we have Batson, of course, but we also have GR37, which is basically Batson on steroids. And in that hearing, that's where the lawyers exercise their perempts. Our final jury is picked. And usually we'll allow at least 2. And now that I've just completed our very first start to finish from voir dire through verdict, taking the verdict, we actually, I had 4 alternates in that case because I have sort of a very, very large, unlimited size courtroom. That's our basic process.
Well, thank you, Judge Williams. What I'd like to do now is to go to our first topic, which is online juror questionnaires. And I'd like to start off by saying that online juror questionnaires or written questionnaires, either one, that is the gold standard for juror disclosure, for their candor, for the amount of information they do disclose, their truthfulness, as compared to an oral voir dire. That's what the research tells us. And so we should be taking advantage of that. What you see on your screen here are the questionnaires that we used in the Arizona jury project. You'll see on the left, you'll see the hardship and qualification questionnaire, or the jury summons, if you will. That was sent out in advance of each of the simulations. And what you'll notice there is that there's a couple of red circles. We had some general background information, very limited. We then had hardship information. We had their ability to sit in a virtual trial, and then also COVID issues. And that all was sent out to them ahead of time, where you could have used that to screen them. On the right side, you'll see the supplemental juror questionnaires. And these are questionnaires that are designed with your case in mind, that you're going to have more demographics or backgrounds that are related to your case. You would have the experiences that they've had that are related to your case, and also opinions that are related to your case. And this is all designed to supplement your voir dire. Now, we have copies of both those questionnaires in the resource section here for you today. Now, what I'd like to do is to, with that as a context, going again to Judge Williams and basically tell us how you used your questionnaires in King County.
Well, we're using an online form that's based off of MS Forms, and if in your jurisdiction, if your court has Office 365, it actually comes free. We're using a secure version of that, so we send an online questionnaire. It can be far more detailed than a form that the jurors have to actually write out. And it, as Dr. Frederick indicated, we get incredibly accurate and detailed information. In my last asbestos trial, we had, there was 97 questions that were asked, and they were very detailed about the life experience of the jurors. Most of the jurors, those that have digital access, will receive it, and they'll complete it either on, as you can see on your screen, they'll complete it on their computer, or they can complete it on a mobile device, and you have a picture of that. And then what the lawyers get back is a spreadsheet that is, again, it's got targeted questions that the lawyers can really use to make their voir dire individualized for each juror. You can conduct, because it's in a spreadsheet format, very, very accurate data analytics. You can rapidly figure out who has specific viewpoints on a particular area. You can rapidly figure out who requires a hardship, who's requesting a hardship, what the basis of it is. And so we've got really good data analytics. Now, I keep mentioning those jurors that are on the other side of the digital divide, and they exist, and we have not excluded them. And we've developed two separate processes to make sure that we include them and that their information gets included in that data as well.
Excellent. What I'd like to do is, before we go on to the next segment, is Ms. Frederick, what I believe in your case, you also had an online questionnaire, and I'm wondering if you could go ahead and share your experiences with that. Charlie, do we know if she's on? If she's there.
Jennifer, are you able to unmute? Jeffrey, would you like to move on to a different question, and we'll come back to Jennifer?
We'll come back to her.
Super.
What we're going to be doing now is I'm going to be showing you a slide. But before we do the slide, I wanted to give a shout out, if you will, to several people. One is Sarah Murray from TrialCraft, who hosted the supplemental juror questionnaire and all the online questionnaires that we used in the online courtroom project. And many thanks to her. To Josh Spolansky from Josh Spolansky Consulting, who produced this video, and also to Natalie Gordon from the John Jay College of Criminal Justice, who helped us in the Arizona project to do data management and data analysis. And the reason that I mention that is that these people are working pro bono, and if all we have is recognition, that is what we want to give them. Now, what you're going to be seeing in just a second, you'll be seeing how an attorney can effectively use supplemental juror questionnaires. And the interesting thing about it is that it'll give us a feel for how voir dire is conducted online, but also keep an eye out for, there's a juror up in the right-hand corner. She'll have a red box around her. This is a juror who did not raise her hand to a number of questions that she should have, but having the supplemental juror questionnaire allowed us to see that she was a juror potentially problematic to the plaintiff. So Charlie, if you could go ahead and roll that, that'd be great.
Ms. Hayes, would you like to inquire at this point?
Yes, thank you, Your Honor. I introduce myself. I'm Jillian Hayes, and I represent the plaintiff in this case. I know this process can be a little uneasy, especially now that we're using this new technology. But I want to assure you that there are no right or wrong answers to any of these questions. All that we are asking for is complete and brutal honesty. We need to know how many of you have a bad taste in your mouth about this kind of case. When you hear personal injury, a slip and fall, trip and fall, does that bring up any emotion right off the bat? And for purposes of this, I think it may be clearest to just raise your hand and then we can kind of go down the line. So does anyone automatically have some bad feelings about a personal injury case, a slip and fall? Anybody? Okay, number 10. Okay, thank you for being honest and brave to be the first one. So juror number 10, can you elaborate on those feelings?
Yeah, I don't know if I would say it's a particularly intense feeling, but I do have an aunt who was...
I want to thank you all for also filling out a questionnaire, a very detailed questionnaire that's part of this process here today. And I want to follow up with juror number 6 on some things in the questionnaire. I noticed you said most slip and falls happen in stores as a result of customer inattention. Would you mind telling us your feelings on that?
So I guess I probably shouldn't have said most. I think many, just because I've heard stories about, people who have slipped or who have planted something and then slipped and tried to sue the store. But I don't have any real strong feelings either way. I mean, I know that a lot of slip and fall cases are certainly very valid, and I just, I think that each case has to be looked at separately, because I think there's a lot of different reasons and causes that things like this might happen.
Does anyone here have kind of that same initial reaction that a slip and fall, you may need a little bit more evidence to evaluate the case because you may be a little skeptical about the credibility of the plaintiff? Does anyone feel that way? Sticking with you, juror number 6, I also noticed on your questionnaire you said people who slip and fall at stores and claim bodily injury are probably lying. Tell me a little bit more about that.
Did I say that? I don't remember saying that. Wow. Well, again, I guess it's just stories I've heard. Maybe that's why I thought that, because the stories I've heard about people trying to cheat the system or do something dishonest.
Okay.
Now, hopefully, Jennifer is back on. Jennifer, can you share with us your experiences with using supplemental juror questionnaires, and we'll see if the mic works.
Can you hear me now?
We can hear you. Thank you.
Wonderful. My apologies for that. Yes, so my trial that was an online jury selection process was a medical malpractice case where I defended a plastic surgeon, and it involved a retained surgical sponge. So we used an online questionnaire similar to the one that you showed, and our judge allowed us to incorporate our own questions specific to the case into the questionnaire. So we had one very long questionnaire that was emailed to the prospective panel the week before. So it got emailed the Monday before we were supposed to select our jury, 7 days beforehand. And we received the responses back by Friday. And of the 150, I think we received responses from 140 approximately. So almost everybody responded. And the court very nicely incorporated all of that data into a spreadsheet through SurveyMonkey. So for each individual juror, we had all of the information line by line by line. My firm then used a very good trial consultant who helped us create single-page face sheets for each juror in the order that they were going to be called, with all of the relevant data that we would use for the online selection process. So it was tremendously helpful to have all of it in one place, and we used it for asking our individual voir dire questions the following week.
Excellent. Now, before we go to online voir dire questions on the logistics, I wanted to raise two things. One, you can have the question of, well, these questionnaires are nice, but is it difficult to implement? Can jurors really complete these? Do they have problems with it? And also, are they really willing to do it? Now, we fortunately have some data from the Arizona project. And what we did is that we asked jurors, after they'd been through, we had three sets of juries completing these questionnaires. And we asked them at the end, how easy was it to complete the questionnaires? And we had 91 to 98% choose the option of very easy. That was the most favorable option, very easy for them to complete the questionnaires. And also, we asked them, well, would you be willing to, how willing are you to complete such a questionnaire if it would shorten the time of jury selection? And we found that 91% said they were very willing to do this. So any conversation that, oh, this would be too much of a burden on jurors and they won't want to do it, or this kind of thing, really, is contrary to the data. Now, that brings us to online voir dire and logistics and challenges. And to kind of set things up, we need to provide an overall structure for effective voir dire in an online environment. And so I'd like the panel to comment on the structure of the voir dire that they went through, panel size, also time limits, if any, did they use staggered panels, and also did they provide devices or provide kiosks for those jurors who, for whatever reason, would not be able to do this in their home. And so I'd like to start out with Mr. Yancey. We haven't heard from you yet. So Mr. Yancey, could you tell us how voir dire was structured in your trial and what you learned from it?
Yes, so in our trial, we did not do the online questionnaire, but we did have 129, I believe, potential jurors show up to the courthouse on the Friday before we started, and they filled out the questionnaire there that was pretty lengthy, and included questions about the issues in the case, as well as COVID-19 considerations, and then the court was able to grant hardships to about 52 of those folks. And so the remainder, provided their email addresses, and then they all Zoomed in on Monday. And so from there, we did panels of 19 at a time. And so, they would have 19 of these potential jurors, and, we went through, questioned them, and did our strikes right there. And so, then we just, added some more to keep that number at 19. So, if you strike 6 at that time, then we'll bring 6 more on and kind of start the process over again until we got to our 12 jurors and our 3 alternates.
Okay, Ms. Petrovich, what about you?
So we used the questionnaire that we generated to do as Judge Williams described, which is go through for hardship. And of the roughly 140 people who responded, which is about 3 times the size of the typical veneer that I'm used to up here in Washington, almost half of them we lost to hardship, mostly due to concerns about the coronavirus, personal health issues, or being too close to the case. There were about 10 individual jurors that identified having personal experience with breast augmentation or issues that we were talking about medically. And we individually did voir dire of those jurors to talk about their issues to see if they would be for cause strikes so that they didn't have to talk about personal information in front of another panel. So that was the first day. And then the second day, we ended up breaking up into roughly panels of 10 jurors, and we scheduled 6 total panels, but only went through, we had enough to do for cause and peremptory, so we knew we could seat the jury. The panel, I believe I was one of the first ones in King County to do this. So the way that it was structured was we had an hour total for each group of 10. There was 40 minutes total for questioning, 20 minutes for the plaintiff and 20 minutes for the defense. But allowing for technical glitches, the judge's instructions, the judge required the jurors to be in a private place outside of the presence of everybody, so it took some time to situate. It really wasn't enough time. I think they've modified the time period now to allow for more time to allow for those issues. But that's how the process went. And once we had enough to seat the jury, the next day we did our peremptory challenges and went back from the start of the panel to seat our jury after allowing individuals without access to internet or a computer the ability to come to the courthouse so that they could present for in-person voir dire.
Very good. And also you make an excellent point, and that is that the online or the questioning of jurors online is a new experience, and you don't have to go through a tech check or have technical difficulties, et cetera, in a previous in-person trial. So we need to think in advance, okay, how much time are we going to need, and is that really enough? To make sure that we don't burn some of our time doing certain things that might not have detracted from the time in previous trials. So keeping an eye on that and making sure you have time is very important. Now, Judge Williams, I'm going to ask you to bat cleanup here. You've done both hybrid in-person online jury selection and then in-person trials, and with in-person voir dire also, along with your totally Zoom trials. Could you kind of let us know if you have any other points to add about this, given that experience?
Well, I really want to emphasize what Ms. Petrovich said, and that is making sure that you have adequate time. But currently, we've actually expanded the size of the number of jurors in each panel. And our general rule of thumb is that the parties will get 2 minutes per juror that they can use however they want. And when you think about it, that actually works out to more time. Because as an example, previously you'd have a veneer of maybe 50 and you'd get maybe 20, 30 minutes. Well, now with a veneer of 15 or a panel of 15, you get 30 minutes. And so you're actually getting far more time. The other thing we try to do is we move the tech checks over onto the judge's time. And so there are steps that each of our judges are now taking. Each of us does it a slightly different way to make sure that the jurors can hear and see and that tech check doesn't eat up the lawyer's time. The issue of the hybrid, and there's two different ways of thinking about hybrid. One is that the entire process, the only voir dire you do is video, or the only video voir dire you do is in person. We have a hybrid process in the sense that we have portions of it that are, and we do have some judges that will have some jurors in the room, some jurors on during a panel, some jurors in the room, some jurors remote. We have found that that is not a best practice. The better practice, because the technology issues, you have some people wearing masks, some people that are not, the broadcast in and out of the courtroom and kind of making that handshake it just creates technical problems. It eats up time. And plus, point blank, the jurors don't like it. And the lawyers find it clunky and distracting. Probably the best practice that we found is you'll have a voir dire panel that is purely video. Everybody's remote. Nobody's wearing a mask. You can see the micro expressions. You get a really good bead on your jurors. And then we have a very small number of jurors that initially, it's interesting how rapidly, once they see how easy the process is in terms of remote, how rapidly they find a way to be able to participate online. But we'll have the jurors that will come in, and usually there's 2, maybe 3 out of the panel, out of the veneer, and they're socially distanced. They're wearing PPE. And the lawyers sometimes are in the courtroom, sometimes they're remote, and we again have a slightly expanded time frame to do that. Bottom line is best practice. Either do video or do in person. Don't do both.
Interesting. Now we have had a question that comes up in many of our minds and has been talked about a lot. Have you had any diversity problems in the way you've been conducting jury trials now? That's been kicked around is going to be potentially an issue with using virtual trials.
Every fear that has been put forward concerning the use of video technologies, once we got into it, we found that the exact opposite was true. And that is a good one, a good example. And because the reality is, for years, we have equated the socioeconomic divide with the digital divide. And what we're finding is today, that's just not true. In fact, what we found by expanding access, we still allow in-person, if the juror wants to come in, they can. But by expanding access, we're getting far, far, far more diverse jury pools because, and again, point blank, because of the socioeconomic divide, more people own cell phones or internet devices than own automobiles. And even stable brick and mortar homes. And so what we're finding, and because we've reduced the amount of time commitment, instead of having to sit in a room waiting for the convenience of the judge and the lawyers for 2 days, and then sitting there listening to a voir dire that might run a day, we have a very narrow window, and people can participate from locations where they don't have to travel. So we've had jurors that have showed up. Yes, they were standing at the cash register because they couldn't, the person was supposed to break them didn't show up, but then they moved into the breakout room where they were alone without distractions and could focus. It actually has expanded the ability of people to participate in the process, and along the way, it has dramatically increased the diversity of our jury pools.
Excellent. Now, Mr. Yancey, you took a different approach. I mean, you know, I compliment Judge Williams on the effect of this technology and the potential lack of a serious digital divide. But you took maybe a proactive approach to this also. Could you speak on that?
Yeah, so in our case, once our jury was selected, the court was actually able to provide each of those jurors with their own laptop that had software on it that would limit what they could access, which was Zoom only. And then they also provided hotspots to each of those jurors so that, you know, Wi-Fi connectivity issues wouldn't be a problem. And there were some technical issues, as with all of these trials, that came up eventually, and some reverted back to their own personal devices. But that was, you know, the plan from the beginning was to make sure to avoid those issues, to just on the front end to provide the hardware and software necessary to allow those jurors to participate.
Fantastic. Now, you know, one challenge, and this comes from the trial consultant in me, is the, well, how do you keep track of all this information? You have this gallery, a gallery view of people, and you have the notes you're taking, stuff like that. And so I'd like to see how the two lawyers kept track of this information. Now, Ms. Petrovich, if you could, you know, kind of share, well, how did you keep track of all the information on jurors? Because you had a lot.
Yes, we had so much information, and we used a trial consultant like yourself, Dr. Frederick, to help us, because it was just so much information and it was a new process to us, and it was really instrumental. But we also we had a co-defendant on the case, and we used my office conference room, which has a very large TV, and we set up multiple other TVs to create a war room. So we had an IT firm come, do all the connectivity, and just the lawyers were on the Zoom, but the other individuals around us could participate without being seen by the jury panels. And I mentioned the face sheets of the individual jurors. So we used the data to create single pages, which was really helpful. And then we were able to take notes on those and also communicate with our co-defendants and our trial consultant and our client in real time, in person and by text message. So everybody was paying attention and writing down their own interpretations and their own memory of what occurred in real time with the information from the questionnaires. We also, the court did a great job of using the juror numbers in the tiles rather than the juror names, so it was easier to track. And then they pinned in order who was going and who was going to be the order that we were going to use for peremptory challenges, so then you could track it easier that way as well.
Excellent. Now, Mr. Yancey, you also obviously had a lot of information to handle. How did you all handle it?
In a similar way. So we were able to get our team in a war room, basically at a hotel in Oakland, which is where the trial was, and we had the extensive juror questionnaire that I mentioned before, and so we were able to kind of anticipate things we were expecting from certain jurors, and then really everyone that was kind of behind the scenes was working vigorously as these questions were being asked, and we were checking the responses from not only those who were being asked the questions, but the responses of everyone else kind of around there. And so again, it was a team effort, right? And so people kind of not on the camera, not doing the questioning, were able to take those notes and then get those in front of the lead attorney or the questioning attorney, and then using Zoom, that platform allows you to pin those images on the screen in that order. And so you can kind of use that to keep track of who everyone is and things like that.
Excellent. Now, that's a good point you mentioned, is that Zoom now allows you to, in essence, and we'll go to the next slide here, Zoom allows you to, in essence, position everybody the way you want them on the screen. In fact, here is an image from the one of the Arizona virtual jury selections, and you see everybody that was part of the questioning on the screen in the gallery view. Now, when you don't have Zoom, it can be a real interesting situation because the tiles can shift all around. Even with Zoom, if there's a loss of internet connection, a juror's tile can automatically go back to the end when they relog in. Now, what I wanted to show you is that we faced this in the Arizona case where the tiles could shift. So what I did in this particular, virtual jury selection, is I took this is the conference room I was in. I was 2,100 miles away from the jury selection. And so you see on the left there, you see the big screen with the assistant who then printed it out, cut out the tiles, and then I was able to, in here you see a spreadsheet with the jurors' images on the left side of the spreadsheet next to the name so that I could always pair up an image with a name. Now, one thing that is important to note is that some jurisdictions would not allow you to do that. So I would recommend that, you first of all, you find out what you can do and then seek assistance from the judge in terms of this is only being used to organize the information and help you in jury selection. You can destroy it at the end, that's fine, but this is what's really needed. Now, Ms. Mistrovich, were you able to do that in your jurisdiction?
No, and I really wanted to. And the reason why is typically when you pick a jury in person, you can see them when you're making your strikes and you can understand who's coming into the box next. But because we did our peremptory and actually seated our jury on Thursday, having already interviewed the panel on Wednesday, you didn't have their faces fresh in your mind. We asked our judge and she said no because she was concerned about the privacy of the jurors, and she didn't want that information or their photos to be associated with anything that they said. So we weren't allowed, but I tried.
Exactly. Now, Judge Williams, I think you take a somewhat different approach to this.
By the way, the most common phrase in a Zoom trial is, dude, you're still on mute. So the reality is this is a very hot topic among our judges. Washington State has an enhanced right of privacy under our Constitution. But this is a very hot issue. And each of us has adopted, we have some judges that absolutely forbid anyone, including the court, from taking a picture. We have other judges like me. I forbid anyone from recording or taking a picture, and I use this as part of my sound check at the start of the process. I ask each member of the venire to unmute and confirm to me that I have their permission to take one screenshot. After the panel is over, I share that screenshot with the attorneys for the very purpose that Ms. Mistrovich is saying, so that when we get to the perempt hearing, they can remember who the juries are. But they're also under a court order that after the trial is completed, those photographs are to be destroyed.
Excellent. And that also gives us some guidance that there might be hope there if you're in one of those situations where you have a rotating screen potential. Now, what I'd like to do is...
Point of asking.
Definitely ask. You have to ask. What I'd like to do now is to shift gears a little bit and talk about juror questioning, because that's really where the rubber meets the road. We want to be able to have jurors participate and be candid in what some people consider really a more intimate setting, because we have the visual images appear to be much closer than what you have in a regular courtroom. So what I'd like to do is to ask each of the participants how how they went about questioning their audience, and what kind of takeaways do they come from their experience that we can then employ in future jury trials. And Ms. Misrovich, why don't we weigh in with you? Could you tell us maybe some pointers that you have?
Sure. My biggest concern with the process was establishing rapport through Zoom. I think it's difficult when you're meeting strangers and asking them very personal questions to get them to like you, to get them to establish a connection with you. I think jury selection in general is one of the hardest things about doing a jury trial, even when you're in person. So I was most worried about that. And all of the advice that I got, which I think was really good advice, was to just be as efficient and concise and to the point as possible. Since everybody's doing these online platforms with all aspects of their life, school, and work, people appreciate directness. They appreciate understanding what the issues are and just getting to the point. So rather than take a long introduction and explaining who I am and what bias means and what burden of proof means, I just went straight into asking questions of write about the case and who would be biased specific to my client. And I thought that was really effective, and jurors appreciated that approach. We also got them to speak a lot more, and since we had such limited time, it was more important to me that they speak rather than them hear me speak. The other biggest takeaway that I had was typically in a regular jury selection process, you would just say, who here has had this experience, and ask them to raise their hand. And we found with our consultant that it was more effective to use finger numbers, 1 or 2. And the example for my case was, it was a retained surgical sponge case, and we disputed causation. So I was worried that jurors were going to automatically assume because a surgical sponge was left behind, there must have been some sort of harm to the patient, which we disputed. So one of the first things I asked them was put up 1 finger if you think because a surgical sponge was left behind, there must have been harm to the patient. And those are the high-risk jurors. Or put up 2 fingers if you think the plaintiff has to prove it to you and it's possible there was no harm. And it was very effective to right away understand who the high and low-risk jurors were, and then to follow up for cause on those high risks, also using the specific questions from the questionnaire. So that was our process, and I thought it worked better than just talking to try to establish a connection.
And you make several wonderful points. Be direct, be focused. You're not there to waste the juror's time. Also, there's a subtlety to the 1 and the 2 type of question, is that you notice that she doesn't have to ask the question twice. How many agree with this? How many agree with that? She's basically said, if you agree with this, it's a 1. If you agree with that, is a 2. Please answer it. And you actually combine the question, going from a multiple question down to a single question. That was interesting. Now, Judge Williams, what about your observations from the bench? Are we muted?
Yeah. First, let's talk about that issue of bonding. In the last panel, Ms. DeCaro, and I believe Ms. Sowers as well, made the point, you can make the connection. You can. It's just different, and it's not what we're used to. But we need to be not afraid of that. In not only my work and watching lawyers conduct this, but also the tests that I've done with my students at the law school, running different types of scenarios involving them having to conduct voir dire. Here's what we found. If you're going to come in and give the first opening argument as voir dire, if you're going to come in and ask those general questions, you're wasting everybody's time. You use the questionnaire. You identify from the questionnaire the people you need to target. And just by hearing their juror number, they get a kind of a positive reinforcement. So you might say, juror number 6, I see that you've been involved in a car accident. Tell us about that experience. And now juror number 6 is engaged, and you pivot and you swing over to juror number 8. Now, juror number 8, you also. And so by doing that, you engage and you connect with the juror. In the interviews that I've conducted with jurors that have actually gone through this process, live jurors, real cases, what they say is, interesting enough, they found the process more intimate and less intrusive. They liked it. They felt that they bonded with the lawyer. The lawyers felt that they bonded with the jurors. But it's different than when you're in person and you can give the first opening argument. Key is those targeted questions.
Excellent. Now, I want to make sure that we proceed in an efficient manner. One thing that I'd also like to pass on, just like in group voir dire, the use of something that I call the springboard method can help you connect more. I mean, we've been talking about connecting. One way of connecting is not only is visual eye contact, but also getting them involved, getting them participating. One thing that you can do is that you can ask an open-ended question at the beginning of a topic area. For example, maybe it's about their feelings about awarding money damages for pain and suffering. You go ahead and you ask juror 1 that. You then ask, you use that answer and then go and ask juror number 27, number 15. You ask a few of them to give their opinions, and then you get an overall poll from everybody so that you know everybody's opinion. And what will happen is that will increase the participation. It'll increase your connection. Now, I'd like to go on to managing communication so that we can get to some questions here. And basically what I'd like to do is that, we're not in our same safe space of pre-COVID. We can just lean over and talk to somebody. And we have different things we have to go through now. And I'd like to ask each of them basically what they did in kind of an espresso version so we can go ahead and take some questions. And I think I'll start with Judge Williams in terms of the attorney judge communication and what you did to have a conversation with the attorneys when needed.
The moment we have everyone in the room, we set up a breakout room for the jurors so that in a moment I can just push the button, open it up, tell the jurors to go in. It takes a couple of seconds. And so then if the lawyers need to go on the record with something, we can do that. If the lawyers need to talk to their clients, again, breakout room. They can go into the client and talk to the client. They're completely alone. And if for some reason I have to be part of a breakout room discussion, doesn't happen that often. If I enter that breakout room, the courtroom comes with me, not the jurors, just the recording system. So breakout rooms.
Okay. Mr. Yancey, how did you handle communication with your team members? Because obviously that's an important point.
Yeah, so, with the judges, again, we handled those communications through the use of breakout rooms and things like that. But for the team, considering that we were all kind of in the same space, but we also had some people who were, remote in our own satellite offices, who were supporting attorneys in Oakland. We use things just like, group messages, text messaging, different separate Zoom rooms, or anywhere you can kind of get a chat function going, whether it's like a Skype for Business, for example, or those kind of devices. But one thing that we made sure to do was that we were careful about our communications, whether we were switching from platform and double checking where we were to make sure it was secure, because we had an incident with the initial judge who, in our case, had to recuse himself after he was, he had just left his audio stream on and didn't realize he was making some comments to his clerk that were heard by associate for one of our co-defendants. We raised the issue of bias to his attention, and he recused himself. So we were careful with, our communications and making sure our platforms were secure.
Excellent. And now, so we can hit our final point here and then take some questions. Is that and this is going to be the lightning round approach. everybody has to exercise challenges for cause and peremptory challenges. There's obviously different systems for doing that. Ms. Smith-Trovich, could you kind of explain how you all handled that in your case?
Yes. So we identified most of the hardship jurors, especially COVID, which was a wide swath. Anybody who raised any COVID question was immediately struck before even going into the jury selection process. We then had other folks who were likely going to be hardships do the one-on-one sessions that I mentioned earlier, and all but one of those were struck in real time. Our judge then asked us to do 4 cause strikes during the actual panel. So when we had 10 jurors at a time, if we were making a 4 cause strike, we had to do it in front of the panel with everybody. So we had to be a little bit careful of not offending anybody and being cautious and explaining why we were moving for cause. And then we did our peremptory challenges all together the last day, not in the presence of any jurors, just with the lawyers. Excellent.
Now, I would like to mention about doing the challenges for cause in front of the panel. If at all possible, there's no reason why you can't conduct that in a bench conference or something like that. There's no, I would fear for the attorney having the soft pedal of their challenge for cause, and then the record is the soft pedaling. So I would say, to do what you can to show the judge that it could be as effectively done here and have advantages to it. Now, what I'd like to do is see, and I'm sure we have some questions. And Charlie, if you could go ahead and see what questions stand out to you, and we'll take a couple questions and then a couple comments.
Absolutely. And we'll start with one from John. John says, Judge Williams, how can we get a copy of your standing court orders regarding the jury selection?
Judge?
Well, that is an interesting question. The short answer to that is right at the moment, though, we do have some templates that we use that are primarily based on our pretrial conference process in both criminal and civil procedures. So we have those. In terms of the process, bear in mind, we're a ship with 53 rudders. There are 53 colleagues. Each of us does this slightly differently. We have the roadmap, and if you go to the King County Bar Association website, you will see a set of 3 instructional videos. One is on this process, and we'll walk you through everything. It's a little dated. We've evolved our processes, but you'll see the roadmap of the process and how we do this.
Charlie, another question, if you will.
Yes, thank you, Judge Williams. A question from David. David says, how do you ensure that jurors' presentation, especially the background, are roughly equal? A juror dialing in from their mansion comes across differently than a juror in a log cabin.
Now, Judge Williams, do you have a kind of a cheat sheet or some way of aligning the camera, et cetera, and providing them guidance on this?
It's not a cheat sheet. It currently is part of my opening instructions at the start of each voir dire panel. I make them turn around and look at what's behind them. I do not allow the use of virtual backgrounds for 2 reasons. One, you get a fade out, but mostly because it causes huge bandwidth issues and it causes processor issues on their devices. But I make them look what's behind them, and if need be, have them turn so that there's a more neutral background. The bigger issue with the jurors, and for the lawyers, you need to think about this for your witnesses, if you're dealing with remote witnesses, make sure they're not backlit, because if they're backlit, it looks like they're in a witness protection program. And I actually got very positive comments from my last jury about the fact that I made them either put lights in front of them or turn so that they weren't backlit.
And Charlie, we'll take one last question, and then I'd like to make a comment or two.
Okay, question from Yakonda. And Yakonda says, if the solution is to provide laptops to all jurors, who is paying for this, the court or the parties? What are your thoughts on that?
Now, Mr. Yancey, you provided a device. Was this paid for by the parties?
It was issued by the court, actually.
Okay.
Yes. They have those capabilities and that technology.
Excellent. And we also have had other presenters that have mentioned that maybe it was a judge earlier today that mentioned that the parties had basically footed the bill on providing these devices, and that was an excellent solution. Now, what I'd like to do is that we only have a couple minutes, and I'd like to take my prerogative here as moderator to do a couple things. One is to say that in terms of us working with online juror questionnaires, I think this is, of all the things that are happening now, I think that this, and maybe even virtual jury selection, but definitely the online questionnaires are something that are going to be staying and should stay as we go forward after the pandemic. I think it's a really good development in our area. And the second thing, I'd like to thank our panelists. I mean, they put in a lot of work on this and provided their insights, and I really want to thank them for devoting their time to this. And of course, I want to thank our sponsors. I have to go back a page, I think. No, well, anyway, we have sponsors, and we want to thank them. So while I'm saying something, that is no longer there. Anyway, sponsors, you have indeed our thanks. And there you go. Thank you so much. And we appreciate that. I'd like to thank Charlie for all her work and echo Chris Dominic's comment is that like she kept it all together for us and made this thing run. I'd also like to thank the online courtroom project and Nita for providing this timely and informative jury summon. This is just incredible. I would also take my prerogative and put a bug in their ears that, hey, what's happening spring 2021? I think that we should have another jury summit part 2, if you will, to help us along this process. So I would recommend that. And then, a personal thanks to Richard Gabriel. Through his leadership, through his devotion, through his commitment to our justice system, he not only formed the online courtroom project, but he also envisioned this jury summit. It would not exist, and everybody has contributed to this thing. Nita has been, right in there, and everybody has contributed to this. But this would not have existed without him. And if we were in an in-person setting, and hopefully we'll get there someday, I would want everybody to give him a hand. And he has my personal hand. And I would now turn it over to him for any final comments that he has. And again, thank you, panel. You've been fantastic.
Well, thank you, Jeff. It's very, very, very kind of you. I really appreciate that. And I think right now I'd like to thank this panel. I'd like to thank all of our panel. And I'd like to thank our audience for joining us for 2 days. I mean, this easily could have been 2 weeks because there was so much information packed in there. And there's obviously a lot more that we could have done. I want to thank the moderators and the speakers. Everyone has devoted so much time to put an effort into putting their thoughts together, their experience, their wisdom from doing these trials, and thinking ahead here. Obviously, Nita for providing the resources, Wendy, Amy, Charlie, our voice of calm and reason, who has kept us all steady and on mark here. Obviously, our sponsoring organizations have been tremendous in providing their support for us. I think what the most important goal that we've had from this whole summit is to start a national conversation, because it's really easy to wait. It's really easy to put it off into the future. It's really easy to think of our own silos, our own practices, our own courtrooms, our own jurisdictions. But it's hard sometimes for us to reach outside and to start a national conversation and to share with each other what we can be doing, what best practices are, so that all of us can have the tools and the resources to proceed ahead to provide greater access to our justice system and greater efficiency and effectiveness in the trials in whatever form they may take. We've come a long way since March. There's no simple solution. There's no single solution here. But I think one of the things we've all talked about here is we don't want to let the perfect be the enemy of the good. And so for that, I want to make sure that we all stay connected. There's a LinkedIn group that you can connect with to offer your comments and to get advice about. There's a survey that we're going to be distributing also, so that we can keep track of your opinions and experiences with online trials. Obviously, you can contact the onlinecourtroom.org, www.onlinecourtroom.org, to ask us questions. I'm sure Nita's going to have programs in the future about this. I think the most important thing is for us to just keep this conversation going. And with that, I really want to thank you for your participation and your devotion to our justice system today. Thanks very much.